Today we'll be discussing about is patent law against competition. So yeah, as usual, we'll start with opening remarks of Shalini.
Hi, Priggya, and hello, viewers. I hope everyone had a fantastic day. Um, so, let's start with patent and competition law. I think, as opening remarks, I'd like to say that the two go hand in hand. If I have to explain it very simply, patent laws prevent your innovation from being copied or being imitated by infringing parties, and thus they sort of complement competition law. They provide a backing for competition law because they promote a fair and reasonable market behavior. Competition law, on the other hand, keeps a check on patent law, in that patent right owners are prevented from abusing their position of monopoly, if you want to call it that. So if this gets too high, this one puts a check on it. If this one gets too high, this one puts a check on it. So the two complement each other, and I think we should explore this in a little more depth.
Yeah, absolutely. So Shalini very rightly said, I think these two do complement in each other, with each other, especially uh, like if I'll start with the idea of patent law. So the idea of patent law was to maintain a balance between the patent holder, that is the innovator, and the public at large. It was never that they'll protect monopolies by the innovator only, but they'll somewhere strike a balance between innovator and the public and at large. Now people may ask how, and for that how I always say that patents are rights which are given in exchange for a disclosure. That means only when I disclose something, and that something is the our patent application which the patent office publishes. It is only when I publish or I exchange my information with the government or with the public, the government gives me the rights. So, in a sense, like when we live in a larger economy or a great population, people can go, they can read about innovation, and the innovation is driven further. They get more ideas about innovating further. So that is also the idea which brings the public together, and it kind of pushes the technology forward. So whole idea of patent law is never to restrict the flow of the innovation. It is always to promote innovation. So I think from the sense of that only we can say they go hand in hand.
Correct.
And then coming to the competition
Competition.
side of it, it always enhances the play of fair market. Like there has to be a fair market, free and fair market. And if IP comes on the way, it kind of keeps check on it. Like for example, we cannot have exuberant prices on the licensing agreements. Then competition law can come in and probably say that there is an abuse of dominant position in the market. So there are things in competition law that keeps check on IP law, but IP law in itself is never made to protect only the innovators or creators. It is always made from the sense of balancing the public rights and the rights of the innovator. So Shalini, I think there is some internet gap with Shalini. So by the time she joins in, I will pick up. So now probably let us discuss what are the provisions of the competition law that may, you know, that may help or prevent patent law. So there are mainly two provisions in the competition law, which is abuse of dominance, and second is anti-competitive agreements. So Shalini is back. Hi
Sorry, I
Shalini.
sorry, there was a lot of disturbance from my end, so I thought I'll log out and log back in. What did I miss?
Okay,
What did I miss?
so Shalini, I think your camera is off because we can't see you. Okay, you are back. So, Shalini, I continued to tell everyone that there are two main provisions in the Competition Act, which is the anti-competitive agreements, and the second one is the abuse of dominant position. So,
Right.
these are two things which kind of intersect with everything to prevent uh, misappropriate market conditions. So, would you like to take up these in details and see?
Um, so I think both of these sections, both of these provisions are subjective in nature.
Correct.
So I cannot say black or white, depending on what the market conditions are. So if I look at the whole how Geo took over the telecom
Yeah.
market and what happened to Airtel and Vodafone and all the other numerous players who were kind of pushed out and or made to merge. Can I say it was bad? No. Can I say it was good? Probably not. So, for me to comment on these in isolation is not a, it's not, it has to be on a case to case basis.
Correct.
So, abuse of dominant power, for example, I think we can go uh, and discuss that over many, many days because each and every line in that abuse of dominant power, that section, is uh, is a potential landmine,
Yeah.
right? What who defines what is dominant power? Who defines what is abuse? So I'm going to bring us back to the patent system and the competition law and talk a little more about the philosophy of how the core principles are tied together in this. So to I caught the beginning of what you said with patent law and what the principles stand for. And then when you started talking about competition law, I had bad network. So if I'm repeating something, please feel free to stop me. So with patent law, patent system, as you rightly said, the core principles of Patent Act, whichever country we look at, they have been framed, they have been drafted in such a way so that the system it fosters innovation. It has, but at the same time, it has to also it has to comply with whatever is the fair market rules. So whatever safeguards, boundaries, whatever have been built into the patent system, they allow it to grant patents or allow patents for those innovations that are going to be uh, suitable or conducive for public interest. And it also prevents those patents, at least Indian Act prevents those patents that do not benefit society. We have quite a few of those uh, built in as well. So, with all these things, these safeguard mechanisms that are available for patent systems, it protects innovations. It does not protect discoveries. There are limited rights that patent owners have. There's a limited duration. There are exceptions to the rights, and you have to show there are conditions of patentability you have to comply with. There are are you working is your invention a working invention? Is it required the by your own country or by another country for for an epidemic or a pandemic or whatever, and then you're required to license it? All these things have been built into the patent system to prevent exactly what competition act or competition law is there for. So those things, those safeguard mechanisms are already built in. And on the other hand, if I'm looking at competition law, it, like you rightly said, it prevents undesirable uh, behavior in the market as a market player. When you are on the playground, you have to play by the rules of the game. You cannot be a bully and force the other kids into into either submission or leaving the playground and going away. So in relation to patent law, if I'm studying Competition Act, then such behavior as the abuse of dominant power or monopolistic behavior, it will cover activities that go beyond patent system. So whatever is not taken care of by the patent system, then we look to the Competition Act or competition law in various countries to see what else do we have to protect us. And such situations occur maybe when there is an exclusive license that prevents, there's a barrier to entry, or there are restrictive selling practice put your licensing agreement, or
Correct.
patent agreements, patent rights are used to freeze other people, other players out. In so we have with, I'm sorry, I'm hogging all the time. Last sentence. We have because of a
No,
fantastic, very fascinating conversation. Competition law and patent law together can regulate how the market of innovation works if it is
correct.
used properly.
Absolutely, Shalini. I just add on a few points which I remember from the patent law. Like we have section 140, which is not, I think, it's not a section which is in limelight of the patent law, but it deals with things like restrictive clauses in the licensing agreement. Like we cannot have restrictive conditions in the licensing agreements. Similarly, we have section 3 and section 4 of the Competition Act, which is anti-competitive agreements and abuse of dominant position. Then in section 3 of the Competition Act, we have an exception of the patent, like
Right.
anything to protect IPR is excluded from the anti-competitive agreement. Similarly, we see that there is an exception, but then in Patent Act also we have a clause which is in line with the competition law. But for abuse of dominance, we do not have any exception for patent holders. That means if patent holders are causing or taking advantage of their dominant position in the market, then competition law can come into picture and stop them. So I think they both in together go very well hand in hand to take care of the market conditions, and they're not, they're not opposite forces, they are working in the same direction, so that consumer, like we say, consumer is the god or consumer is the guru, and consumer should not be harmed. So if
Correct.
consumer should not be harmed, then patent law and competition law go hand in hand.
Yeah. So I like to think of it as a Goldilocks situation,
Mhm.
with too little IP or too much IP and just the right IP. So if
Yeah.
you have too little IP where there is not enough enforcement mechanism, or there, your IP cannot be protected, or you cannot differentiate your IP from others, and imitation is, and then it gives rise to imitation, infringement, and so on. When there's too much IP, there is undue abuse of the
Yeah.
IP laws. And even if there are non differentiating features, IP tends to get the patent or trademark or copyright, whatever IP it is, tends to get granted. And this becomes anti competitive in nature, because then you're allowing for each and every mechanism and feature to be patent, to be protected. So if it is seen with Competition Act, then we get the Goldilocks moment of just right, where it is the IP is the perfect quantity, because so IP is by nature competitive in nature, right?
Yes.
It is, it has elements of competition in it, but if it is just the right amount of IP, then it gives the consumer the right to choose what they want.
Yeah.
And if you have, but if it also takes care of abuse of IP rights, it takes care of IP in the right dosage, right? Makes it difficult and inconvenient to be copied and
Yeah.
imitated, as well as to be abused by the IP owner. So
Correct.
there and we identify that sweet spot.
And I think our courts are doing like they're taking care of it, especially in the cases of standard essential patents. We see that Competition Commission of India always comes into picture, and then we have High Court in the picture, and there is a tussle between patent owners. Oh, is it a competition case or it is a IP case? Should whether CCI has jurisdiction or no jurisdiction? But in the latest case laws, we see that Delhi High Court has said specifically that okay, in abuse of dominant condition, CCI has power to get into picture and do the investigation. Nobody can stop CCI from doing those investigations. So I think that is a kind of a right move where CCI comes into picture and takes care of it. That no misuse of IP is taking place.
Correct.
So
I can't see
Shalini,
the comments, so if there are any comments, let me know.
I don't think today we have any comments or yeah, even I cannot see the comments. That is okay. But I think we had a very good discussion on competition and patent law.
Yes. So there used to be, right? We used to have a Monopoly and Restrictive Trade Practices Act before the Competition
Yes.
Act, and but that was gone before I started law school. I think MRTP was abolished. Uh,
Mhm.
but I think the our Competition Act is in line with the provisions laid down by TRIPS,
Correct.
and we've done a very good job uh, of at least taking care of that part of competition, anti-competition, patentability, and so on. So there is, um, so there is, since IP, uh, of course, it's intangible, but it is also an economic asset. And competition law exists to protect people's financial interests, economic interests. So there is this lovely relationship between competition, innovation, um, patent, and that relationship is based. And it is complicated if you're adding each one in isolation. But I think if you sit with the act and you see how it is dependent on patents and you see it is dependent on competition and where innovation all of this, where it can benefit the public as well as take care of it not going into the anti-competition zone, then I think it's a beautiful place to be in.
Yeah. I think all are as again I'll reiterate it. It's dependent on market and the is market suitably accepting or not. If it is working with the market well, the patent law or the IP laws and the competition laws both have to work well with the market. If it is not working well with the market, something wrong is happening. But otherwise, both are there to protect the market condition.
Absolutely.
Yeah. And yes, so I think we'll wind up today's session. And my last thoughts would be yes, both laws work together hand in hand to protect market conditions and IP laws. For IP laws, there is a check by Competition Act. We cannot have unreasonable rights. The rights are given and the rights have to be practiced within those four corners. We cannot exceed the rights what are given to us. And
Absolutely.
Shalini, would you like to add some last remarks?
No, I think I've hogged the time today a lot. Um, but yes, I think this is. I think we should come back and do this session again.
Yes, and I think we should do it by step by step. Okay, patent law is this, competition law is this, and then how they interact because there are so many provisions which we can discuss. There are standard essential patents, competition, then in competition law, section 3,
Compulsory
exception,
licensing is there.
compulsory licensing, rights, patent rights in
So
itself.
Yeah, so I think we should sit with the Patent Act and the Competition Act side by side. Maybe you hold one act, I hold one act, and we dissect it section by section over a few weeks.
Yeah,
Because I think it's very relevant in today's market to be aware of your boundaries in the Patent Act as well as your boundaries in the Competition Act, and make sure that you are not that someone is not encroaching on your rights where it's vis-a-vis patents, and you're not encroaching on someone else's rights vis-a-vis Competition Act.
perfect.
So there is to find the perfect balance. So I think we need to do a few more sessions on this topic.
We'll do a series on this topic so that all of us are clear on what's happening in the market. And we'll discuss the geo case in detail because that is my favorite.
Yes. Done.
Thank you everyone for joining. Thank you, Dr. Tom. Thank you, Shalini. And bye bye. We'll see you next Tuesday.